All right. Thank you very much for coming out today. It's the first nice Saturday that we've had in a long time, and instead we're in here. When it was first going to be held at the brewery, I was like, well, at least there'll be beer. So, although this is a great place and we're able to have a lot more people. So my name's Helen Slottje. I'm an attorney with a nonprofit law firm called Community Environmental Defense Council. We're based in Ithaca. We're solely devoted to Marcellus Shale type issues, and we work for free. Although grants from foundations and donations and the like are gladly accepted, but we don't charge the clients we work with so that they're in a position to obtain the help that they need without having to worry about trying to pay for the lawyers. So next slide, please. So just to give you a quick overview, while I may be a lawyer, today is educational advice. You should talk with an attorney, before trying this at home. And sort of a quick outline on what we're doing today. I'm going to talk a little bit about the need for local action, sort of where you can derive your local power from, some things you might do. You heard a little bit about the comprehensive planning, the foundation for taking those actions. We'll hear about implementation from our next speakers, and then grassroots petitioning after that. So sort of the complete package, a whirlwind tour. There is a handout with this entire presentation on it that's in the back. I'm not going to read the slides or go over absolutely everything that's in the slides. I just wanted you to have that for informational background. So do not fear. I'm not going to talk about everything that's on the slides. So next slide, please. So you might ask, why are we even in this position? Wouldn't the federal government, the local government, state governments, isn't somebody going to take care of us on this? And apparently in the movie Frack, which is now circulating, they quote Mark Ruffalo, who says, well, if there's no problem with fracking, then how come there are so many problems with fracking? So it has become sort of clear that despite assurances to the contrary, that there are problems that are happening in other communities. And so, and that's because of a failure on the part of the federal government and the state government in other states to take care of this problem. Just to highlight, one of the things industry will tell you is that they're subject to any number of these laws, that they have to comply with their regulations. Well, that's technically true. They have really good lawyers, so they get to say, they come up with these statements that are technically true, but not in anything approaching the ordinary meaning of the words. So take CERCLA, the Comprehensive Environmental Recovery, boop-de-doop. So that defines hazardous substances. And so it talks about there's liability if you dispose of a hazardous substance. Well, guess what? Petroleum and natural gas are not hazardous substances. They are wholesalely excluded from the definition. And this can be a problem. A lot of landowner coalitions, we've drafted this terrific lease. We've tied our definition of hazardous substance, and they're on the hook for everything, and we've cited all these environmental laws. And if anything happens, we're going to say, look at these laws, look at these definitions. We defined hazardous substance, based right on the federal law. But that doesn't, you'll find out with RCRA, that doesn't include petroleum, crude oil, or any, natural gas liquids, etc. So there really is sort of, and that just happens again and again and again. And not just in 2005 with the Safe Drinking Water Act, and not just with the Halliburton loophole. Some of these exemptions were built in, from 1972 when the laws were passed. So those aren't going to help us. Next slide, please. So what about at the state level? So the state will tell you that they have these terrific regulations for oil and gas. The state has about 4 or 5 pages of oil and gas regulations, actual regulations. The way that they regulate the oil and gas industry in the state of New York is through permit conditions. Why? Because permit conditions, despite the fact that they have this generic environmental impact statement and say it's really going to be the same everywhere, we can go and do this one impact statement for the whole state and not have to really look at site-specific things. The DEC, out of the other side of its mouth, said, well, it really depends which location you're in, so we need the flexibility to impose site-specific permitting conditions. The problem with site-specific permitting conditions is there are no regulations. So when you don't like the site-specific permit conditions, you can't complain because there wasn't a regulation that said they had to do X. They don't have to do X. They can do whatever they want to do. And in 1992, this oil and gas appointed commission came to New York. It goes around and visits all these states. It's called Stronger. And they spent 3 days sitting down with the DEC talking about how the DEC did business in 1992. They came up with a ton of recommendations, all these things that they really thought, the industry people thought New York could do a better job on, because they're trying to, put a good face on themselves and say, well, we work with the various, state permitting agencies. So not one single recommendation from the Stronger 1992 report has been implemented in the state of New York. So we're not really going to get too far with the state. So next slide, please, and then quickly the one after that. So what can we do? We hear a lot about New York is a home rule state, and that is the case. The Constitution was amended in 1964 to grant, to sort of, they passed this whole sort of home rule package. And there is a constitutional provision, and there are provisions in 3 different sections of the state laws, the municipal home rule law, the statute of local governments, and then the various town, city, and village laws that all sort of grant power, amongst other places where towns can get power. But there's sort of this wide grant of authority to towns, particularly to make decisions that affect the health, safety, and welfare of their residents. So we have this basis for power. Next slide, please. But we hear, or we used to hear a lot about how, well, we really couldn't do anything when it came to oil and gas because the feds and the state were doing such a good job, they didn't need any more help at the local level. And they'd refer to this statute that is up here. And so when you read it for the first time and you don't sort of know, again, sort of what all these words mean, the statute talks about not regulating or passing ordinances that relate to the regulation of the oil, gas, and solution mining industries. So, and then the second part of the sentence talks about how it doesn't supersede local jurisdiction over local roads or the rights of local governments under Real Property Act. But it's a semicolon. So the way, boring lawyer talk, but the way you look at this is an express preemption. The first part of the sentence is, and when there's express preemption, the state of New York says you don't have to go looking around for implied preemption. You're limited to what they expressly preempted. So you don't go looking at policy and whether there's a comprehensive regulatory scheme. You look at the express preemption only. And then the exception clause cannot be used to expand the express supersession. That's an exception to whatever was suppressed, but it doesn't, statutory construction says you can't use that bottom sentence to make the top sentence bigger. It only makes the top sentence smaller. And so you have that kind of going on, and then you go and look at, well, what does relating to the regulation mean? What's regulating a business? And so the courts have said if it's really just anything that impacts them, well, that's everything. Like you couldn't really do a thing, at a town level when there are these towns generally can't regulate the operations of different businesses. So what is this, sort of what are you talking about when they can't regulate the oil and gas and solution mining business? In the mining case, very similar language, the court said, well, that means operation and process. You can't tell them how big the well bore is, what kind of cement they have to use, what the bonding requirements are. All of those things are off limits. But this doesn't mean that you can't use your local land use and police powers, that sort of generally applicable laws that happen to apply to the oil and gas industry are not a regulation of that business. You're not looking at the operation and process. You're simply doing the fundamental purpose of local governments, which is to make local land use decisions. That's one of the primary reasons why we have local government, is to make local decisions, and there's sort of nothing more paramount in these local sort of zoning decisions when towns decide to implement that we're going to create quiet places, we're going to create places where there isn't a lot of traffic, and the courts have all said that is a great thing to do, that There's a right to peace and quiet. You have a right to solitude. And if you're a town, if you live in a place where you have that right, that's a right too. So next slide, please. So that gets sort of to this slide where local governments do have these police powers, and we hear a lot about, well, it's my property, I can do whatever I want with it. If I want to bring this big industrial use and put it on my land, that's just too bad for you. You know, I have the right to do that. The background of property law is this whole concept of everyone has the right to generally use their property as they see fit, so long as they don't negatively influence the people around them. Because no one has property rights if all it takes is your neighbor to do something dramatically drastic, like, you know, cut away the side of the slope and, you know, the mountain falls down on your house, or they put a nuclear power plant in and the like. That zoning exists, and before zoning, general property rights recognize that no one had the right to a nuisance. No one has this affirmative ability to just do whatever it is they want without regard to the negative impacts on other people. And when you think about gas drilling, I'm not opposed to natural gas per se. I mean, I think there are climate change problems with it, but that's not the issue. What has everybody so hopped up is this idea of this terrible traffic, the air pollution, the water contamination. That's what has people out here on a Saturday afternoon, not because you're interested in, like, telling your neighbor they can't do what they want to do. This is about protecting the community's rights. So that's sort of generally, and you have this power, you have the power to say no, and they've said you don't have to allow wholesale mineral or other natural resource extraction in your town. Supreme Court, well, the Court of Appeals of the state of New York, which is like the Supreme Court in our state. Next slide, please. Sorry, I'm trying to rush through all this. So the zoning power comes out of the town law as well as the municipal home rule law, and does talk about zoning generally is done in accordance with a comprehensive plan. There are specific purposes that are set forth in the various town, village, and city codes. And you can use zoning to reduce traffic congestion. So you can say that a land use is not allowed based on the traffic that land use generates. And you can not allow uses because your town doesn't have the resources and the infrastructure to support that land use. Court of Appeals cases in the state of New York, you can just say no to those uses. So next slide, please. So we heard a bit before about the comprehensive plan. This is sort of some of the same thing. What the comprehensive plan does in particular is show that you're not engaging in ad hocery. You're just making things up as you go. So the general idea of zoning is you're supposed to, or any sort of town action, I can't attribute these requirements to any of the federal or state actions that I have seen lately, but it's supposed to be consistent, rational, not arbitrary, designed in sort of good faith, looking for the public interest. And they don't look at legislators. Town board members are allowed to have opinions. That's why you got elected. People have opinions. You have to have an open mind and be willing to listen to what your town is saying. But what the courts look at when they go to decide whether a law is constitutional or not, or was properly enacted, they look at whether you could have had a good reason to enact the law. It really helps to have had good reasons. But the only things that they won't, what they'll look at on an individual level is sort of fraud, corruption, or financial conflicts of interest as compared to sort of positional conflicts of interest. So next slide, please. So I'm going to go through just a couple of different ideas. This isn't a comprehensive list, hence the sum, but sort of some things to start thinking about. So next slide. So we hear a little bit about, what we really need to do is put together some road use agreements and road permitting systems. And we sort of start with this idea of truck routes. And that's clearly something you can do. There's a statute and the materials that you can look at. Next slide, please. But what you can also do in many instances on certain town roads and, town and village roads is prohibit certain traffic. Again, on the theory that this is a residential area and that you're not going to allow certain heavy commercial industrial traffic through these areas. So as compared to sort of starting with the idea that, we have to let them through and trying to negotiate a deal, and that's good for the roads you can't control, and you might have to let them through on. But there are roads that you can just, based on rational reasons and studies and the character and the strength of the roads, but you can make decisions because highways are for the ordinary use, for reasonable use, for the rights, for the common use of the people. So if a particular right is going to be or particular traffic is going to be unsafe, it's too wide for the road. It's, there's bicyclists and pedestrians and kids playing in the street, and you've got these big trucks. You can just say, this road is not suitable for that kind of traffic, and this sort of use is excluded. Next slide, please. So similarly, there's a case that this is a third department case, but that sort of highlights and goes through these sort of rights that the community has. Next slide. So then, just in the materials, and I won't go through any of these, but these are some of the bases for towns, and then the next one is cities, and the next one is the counties, that talk about the right to exclude trucks. So it's not just about establishing haul routes and trying to come up with road use permits. In my opinion, part of that negotiation or action at the town board level should and could include a decision to simply make certain streets that are not appropriate due to their rural character off limits. And many of these roads probably couldn't be fixed to be upgraded to a 4-lane superhighway. But even if they could, a community has the right to say, we want tree canopies, we want trees on the side of the road, we want this nice country road. We don't want big shoulders and this big wide super improvement of the road. Even if you're willing to do it for us, we don't want that kind of a road. That's not a customary road in our town, that's not a reasonable road in our town, and we're just going to say we don't want that. So as compared to, this is from the Delta Engineering package, they talk about if you look at your roads and you determine that certain roads, based on this, they'd be fine for regular traffic, the sort of traffic you've had, but if this heavy industrial use is going to destroy the road in 1 year or less, in that case, the road segment should be upgraded prior to the developer use. So the taxpayer should pay for that. So some of this sort of plan of, we're going to just enter into these road use agreements, I think towns could be giving things away, affirmatively allowing traffic that they might decide after it starts that they're not interested in, but now they've entered into a contract. The gas company has a property right in using your roads as it sees fit. You've agreed to that, and now you've got to chase them down enforcing a contract instead of enforcing your police powers under the statutes of the state of New York. Next slide, please. So, next one after that, please. So the other sort of, in addition to these exclusionary rights on the roads, we believe that there's a right to wholesale exclusion of these high-impact industrial uses. Again, defining the use based on its negative externalities on the other properties, that you're not saying simply, and some towns might choose to do this, but if you simply say, we're going to ban oil and gas drilling, sort of that's one thing. But if you say we're going to ban something based on its negative impacts on other people, that sort of sets you up nicely for what you're prohibiting. You're not just arbitrarily prohibiting something. You're prohibiting something that by definition has negative impacts on other people, which by definition you have the right to do. So some people say, well, isn't this exclusionary zoning? I know you have to have mobile home parks. You have to provide for adult entertainment. State of New York has said, in this one instance, corporations basically, an industry isn't a person, and you can exclude an industry from your town. Even if you can't keep people out, that doesn't mean that any and all industries that want to locate in your town have a right to come in and set up shop. Next slide. So, and then getting back to that, the property rights argument, I have the right to do with my property. You're telling me I can't do what I want. You've taken something from me. Basically, you can't take away a right somebody never had. And to the extent that there's never a right to a nuisance, there was never this right to come in and put, particularly in towns with zoning, an industrial use. Simply by entering into a lease, you create your own industrial zone. And, now people can't tell you no. If I entered into a lease with a nuclear power plant and they wanted to put it in my backyard and the town said no, like that's not an allowed use, you never had the right to do that. Nothing to take away. You also tie into the rule of capture in New York. Nobody owns the natural gas till it's brought to the surface. So all you're really talking about is this limited right to explore that's sort of very ambiguous. And, you can't put, it's not like you're taking away the profits here. You're taking away this one very small segment of the bundle of rights, this right to explore for natural gas, defined in a manner that you're only barring natural gas exploration effectively that has negative impacts on other people. So not a property right in the first place. Next case. So this is, I mentioned this earlier, this idea of prohibiting uses due to traffic generation. And so there are some sites in here about how that works in the state of New York. Next slide. Supreme Court cases, United States Supreme Court, that talk about the ability to exclude industrial uses from residential areas, that communities can act to preserve the environment. And again, we're sort of setting this up so that the only things with sort of our proposal of how to proceed with this, you're only excluding things, and not just gas drilling, sort of this whole panoply of negative industries that follows the gas wells around, disposal of the solid waste, and we'll get to that in a minute, the various exempt wastes that come up, sand trucks, rail traffic, the various chemicals that have to come in, compressor stations, pipelines. There's a whole bunch of things that come along with this. So the idea is to try to come up with, to look at, the way we approach this is, well, what is it? If it isn't natural gas that we're opposed, what is it that we don't like about this kind of natural gas drilling? And then look at those impacts and use that to define what it is that we don't want. So if it changes and there isn't all this truck traffic and there isn't underground injection of chemicals that don't come back up and there isn't this, that, and then it's not a high impact industrial use anymore. No problem. But as long as it has these negative impacts, that's what you don't want. That's what you're prohibiting. Next slide, please. So this is another case talking about denying a use based on traffic. Next slide. So we also suggest prohibiting unregulated pipelines. Again, as a general concept with preemption, if the state or the federal government regulates something, a locality can't regulate it, there are certain pipelines of a lower quality and not as long that the Public Service Corporation doesn't regulate. They're not regulated, therefore you're not preempted, therefore you can prohibit them if you can find a rational reason that you want to do that. Habitat fragmentation, invasive species, the associated compressor, stations, etc. So safety reasons, given some of the history of what's going on. Next slide. So other things you have to worry about include, as I mentioned, these compressor stations that have all sorts of emissions and the like. And it's important, one of the things we've been doing a lot of sort of going around in different communities where they're permitting activities that are precursors to drilling here. Sand plants, metering stations, selling water. And it's very important how your zoning code defines public utility. Most people haven't paid too close attention to that, but you want to have it be a public utility that's actually regulated and is providing a service to a customer versus these sort of early or midstream pipeline operations that aren't pipelines that are actually serving customers in your town. Next slide, and next one after that. So one good thing, until there's a bill presently pending in Albany that would declare what are now considered to be solid waste, hazardous waste, so that have to be treated as such. Until such time, they're solid waste. Clear authority in the New York state cases and case law, statutes and case law, to prohibit dumps, solid waste, disposal, injection, etc., in your town. So we can take advantage of the exemption from hazardous waste say, fine, it's solid waste, we get to regulate solid waste, we don't want it. Next slide. There's been an argument with DEC about whether or not you can have local control over the speedies permitting process or not. There's case law out there that says that you are not preempted from having more stringent local speedies regulations. Next slide. Again, there are exemptions presently in the Safe Drinking Water Act. That is the Halliburton loophole. But the Safe Drinking Water Act itself says that it does not diminish in any way the ability of localities to implement their own Drinking Water Act protections. Under the sanitary code provisions, public health law in the state of New York, municipalities have the right to protect their water supplies. And you're tying this to a federal statute, therefore the state, it can't sort of preempt the federal government. You're implementing the federal statute. So we believe you can use the Safe Drinking Water Act, like a mini Safe Drinking Water Act, to protect resources in your town. And the last slide, air pollution control. There's clear authority for localities to have air pollution laws that would affect this. So again, focusing on the negative impacts, focusing on public health, safety, and welfare, we believe that there is a lot that communities that are motivated to protect the health, safety, and welfare, to protect their rural character, to protect local agriculture, local economies, that there's a lot you can do, and you don't simply have to sit back and wait for this to happen. Thank you very much.